Yeah, it's going to start in 30 seconds, Indira.
Yes. Be ready, please. All the best, all of you.
Thank you.
Thank
Thank
you.
you.
Yeah,
Thank you.
thank you.
Shall I start? Shall I start?
No, 1 minute 23, 1 minute 25 seconds.
I think we should start.
Yes, sir. This
I don't know.
live stream is showing 2 minutes 18 seconds. Live
No,
stream.
that is all. It's elapsed.
Okay, sir. This.
We are
Shall I
already
start,
live.
sir?
We are already on live.
Like this. Intellectual property can be used to create a moat, but it has a limited shelf life. Better yet, invest constantly in creating new intellectual property to replace what will inevitably expire. Good morning. Respected Director General Professor Abhiramakrishna, Vice Principal Dr. M. Srinivas, Head Department of Commerce Ms. N. Sunitabai, and my dear teaching fraternity. On behalf of Badruka College of Commerce, I, M. Indira, coordinator, take this opportunity to welcome our today's resource person, Dr. Nidhi Ruday Buch, and the participants from various colleges and universities to this webinar on intellectual property rights, significance and challenges. Hope you all will have a good takeaway from this webinar. Thank you. Now I request our Vice Principal Dr. M. Srinivas to speak on this occasion.
Yeah, namaste. Good morning, dear viewers. I, Dr. M. Srinivas, Vice Principal, on behalf of SGGBES, Seth Ghasiram Gopikishan Badruka Educational Society, and on behalf of the teaching and non-teaching staff of Badruka College of Commerce and Arts, welcome you all, the guests and the participants, especially today's chief guest, Dr. Nidhi Ruday Buch, who is very kind enough to spare her valuable time with us. We are thankful for your readily acceptance to speak on intellectual property rights, significance and challenges. We heartily welcome you, madam. Yeah, before going to start, dear friends, we regret to inform with profound grief and sorrow that recently our beloved chairman emeritus Raja Hariprasadji Badruka left for his heavenly abode on 6th July 2020. We thought this is the right platform to salute the divine soul. He was a great visionary and philanthropist who served this esteemed institution more than 5 decades. He played a significant role in the growth and development of Badruka Educational Society through his dedicated and involvement for over 50 years. Thank you. Now, once again, on behalf of Seth Ghasiram Gopikishan Badruka Educational Society, I welcome the chief guest, Honorable Dr. Nidhi Hriday Buch, and participants. Having the credit of being the first College of Commerce affiliated to Usmania University, Badruka College of Commerce and Arts made its beginning at Darul Shifa of Hyderabad in the year 1950. Later, it was shifted to Kachiguda premises, which is endowed with excellent infrastructure. More than 60,000 students passed out from the portals of Badruka and are well placed in various fields across the world. The college is re-accredited with B++ grade by NAC in the 3rd cycle. Now, I request our Director General. Before that, I congratulate our Commerce Department HOD, Ms. Sunita Bai Madam, for her and her team for organizing this webinar on intellectual property rights, significance and challenges, which is very important and need of the hour in this pandemic significant scenario of the world. I hope this session will be fruitful for all of us. Now I invite and request our beloved Director General, Professor Abhirama Krishna sir, to give his message.
Thank you, Dr. Srinivas, and morning, everybody. Seth Ghasiram Gopikishan Badruka Educational Society was set up, this first college in 1950, sorry. So this year marks a very, very important landmark in the history of Badruka Society, since we are celebrating the 70 years of our existence. In other words, we are celebrating the Diamond Jubilee this year. The last 70 years, the management has been engaged in creating in our students an enlightened, spiritually inspired, morally upright, and socially committed citizens. We owe it to the progressive management, philanthropists, corporate leaders, and well-known educationists who have guided us in the past and who continue to guide us even in the current times. I'm happy that the Badruka College of Commerce and Arts is hosting yet another very important webinar, especially on the topic of intellectual property, which is very relevant and current. I'd like to thank our host for inviting Dr. Nidhi, who will share her thoughts on this very important subject. I wish the webinar all the very best, and I'm sure the participants would take away rich learning, and I'm sure the webinar would be very interesting and informative. Thank you for giving this opportunity, and over to Ms. Professor Sunita, HOD for Commerce.
Thank you, DG sir. A very good morning to every participant across India and abroad. The Department of Commerce of Badruka College of Commerce and Arts is always committed to make an earnest endeavor to enable our students to develop independent thinking, decision making, leadership, and personality development to meet the global challenges. Intellectual property is an outcome of distinct types of human imagination, creativity, and invention. They are intangible but have great impact on business and economy. Due to scientific and technological advancements, the prominence for intellectual property has increased many folds. In the present fast-changing economy, the recognition of intellectual property, protection of intellectual property, and establishing the rights through government has become very essential for individuals and business to reap the benefits. To understand more in detail and to enhance our knowledge on intellectual property, Badruka College of Commerce and Arts has organized a national webinar on intellectual property rights, significance, and challenges. And for this, we are fortunate to have with us a prominent and scholarly personality, Dr. Nidhi Hriday Buch, Assistant Professor of Law and Director, Gujarat National Law University Center for Intellectual Property Rights, Gujarat National Law University, Gandhinagar. Dr. Nidhi Hriday Buch is a committed Assistant Professor of Law with over 17 years of experience at UG level and 8 years at PG level. She is Director of Gujarat National Law University Center for Intellectual Property Rights. She graduated in economics by securing 3 gold medals, persuaded law with meritorious award. She stood first in LLM with commercial law specialization in Gujarat University. Apart from NET and SLET in law, she completed her PG diploma in intellectual property rights from IQAC and earned her doctoral degree from Gujarat National Law University in the area of intellectual property rights. Dr. Nidhi gained wide experience as consultant on intellectual property rights with National Institute of Design, Ahmedabad. She is associated with various law schools and management institutes in the capacity of visiting faculty. Her research and teaching interests are intellectual property rights in general and trademarks and copyrights in particular, women and law, legal systems of the world, legal education, law of civil procedure, and legal drafting. As a qualified advocate, she worked in the Chamber of Senior Advocate at Gujarat High Court. Dr. Nidhi is also associated with Gujarat State Judicial Academy as visiting faculty, imparting training to newly recruited judicial magistrates for the state of Gujarat. She has presented more than 20 papers at various international and national conferences and seminars. Few of her recent presented international conferences are Geographical Indications, Legal Vehicle for Rural Development, Sui Generis Protection for TK, a step towards sustainable development, Artificial Intelligence and Intellectual property, an inevitable interface, adding life to centuries dying art. As resource person, she delivered more than 50 lectures and presentations to various state judicial academies, law schools, and management institutions across India. Few of her presentations are salient features of Indian Patent Act in comparison with US and European Union patent system. Geographical indications, an important IP tool for socio-economic development. National IP policy, IP in startups and IT industries. Intellectual property regime in India, an introduction. She published more than 15 journal articles. For her outstanding contribution in the field of intellectual property, she was conferred with IP Academician of the Year for 2017 and 2018 by Intellectual Property Protection Organization. In the capacity of Director, Center for Excellence on Intellectual Property Rights at Gujarat National Law University, Dr. Nidhi is actively involved in teaching, research, and extension activities organized by the center along with 3 chairs, that is, Microsoft India Chair on Intellectual Property Rights, GNLU Guj Coast Research Center of Excellence on IP Laws, Policies and Practices, and Department of Industrial Policy and Promotions, DIPP Chair for IPR. Dr. Nidhi ma'am, we are highly honored to have you as resource person for today's webinar. I request you to enlighten us with your knowledge. Over to Nidhi ma'am, please.
Thank you very much for this generous introduction. I am truly humbled. Before I begin with my presentation, I would like to take this opportunity to extend my heartfelt gratitude to Badruka College of Commerce and Arts, Honorable the DG of the Institute, Vice Principal Dr. K. Srinivas, Sunita ma'am, who has invited me and who has organized and taken all pain for this webinar, Ms. Indira, who is the coordinator for this webinar, and Mr. Naveen Kumar, the IQAC secretary. Thank you very much for inviting me. And with the introduction, as I mentioned, the general introduction, I'm sure must have raised expectations in the minds of participants to a great extent. I will try my best to justify that. I will try my best to meet with those expectations. Without wasting much of my time on these formalities further, I'll straight away go to the topic that has been given to me. The topic which has been given to me is, as we can see, I'm sure it is visible on the screen because I have shared my screen. I'm sure my presentation is visible on the screen. If not, I will just start. Meanwhile, the technical will be sorted out. My presentation topic is intellectual property rights, significance and challenges. The topic is with the colon divided into 2 parts, IPR and significance and challenges. Whenever we have to talk about significance and challenges related to any particular topic of or area, it is generally dealing with the advanced level of understanding. And as a teacher, I'm tempted to first go to the fundamental and then I will deal with the advanced part of it. So that is how with a colon there is a division. I will first talk about IPR, the conceptual part of it, and then we will go to significance and challenges. The scheme of my presentation is in this manner. I'll start with the concept of property. We'll try and see where on the classification of property the intellectual property is located. Then I'll take you to the meaning and the nature. We'll look at the rationale for protection of intellectual property. It seems that intellectual property is a buzzword these days, but is it so? That we will try and assess. Then we will look at because intellectual property is an umbrella term under which there are various forms, there are various types of rights which are recognized by law. So we look at intellectual property rights, and intellectual property laws, which are tools for getting rights over this form of property. For that, we need to look at types. And then reasons for emerging importance. I think this much of discussion will be sufficient for us to look at the significance and challenges. With this, let me take you to the concept of property. This is what we are going to discuss throughout this 50 to 60 minutes that has been allotted to me. So we will discuss different forms of intellectual property. But before that, as I mentioned, there has to be certain fundamental or created, or there has to be some background with which we can talk. So for that, let us look at the concept of property. What is property? I think we need not explain this. We know that something which has got commercial value can be said to be property. Now, the concept of property as we knew earlier and as we know now has undergone a drastic change. It has continuously evolved. I think one can say that such kind of evolution, as far as such concepts are concerned, are mark of growth and prosperity of human civilization. So impact of industrialization and globalization certainly have added a lot to it, and the concept has undergone a change. I may say that the impact of globalization certainly has added a lot to the emerging importance of intellectual property. So if we look at it from the legal term or legal language, we are talking about the ownership part when we are talking about property, and ownership means it's a formal legal right which is giving an opportunity to possess the property and also to keep it secure. Meaning thereby, friends, whenever we talk about property, we are talking about three things. We are talking about ownership, we are talking about possession, and we are talking about the security of it. I think these three things remain constant, irrespective of the form of property. So if whether we are talking about physical form of property or we are talking about intellectual form of property, it remains constant. How? That you will soon come to know throughout this particular presentation. Now, where do we locate intellectual property as far as the classification of property is concerned? We know two types of property, tangible and intangible. In popular terms, it is physical form of property and intangible form of property. Under tangible, we have movable like jewelry, we have immovable like buildings. Under intangible form of property, we can locate intellectual form of property. Whichever is the form of property, of course, human has a lot to do with it. But the major distinction between these two forms of property is that as far as the intellectual property is concerned, there are certain rights which are little limited, which are granted. And as far as physical form of property, there is no compulsion to use your physical form of property, right? I purchase a car and I don't want to use it. I purchased a Mercedes Benz or BMW. I've parked it in my garage and I'm looking at it every day, early morning, while having sip of my morning tea and reading Times of India and feeling blessed and happy. That's okay. I may not get it out of my garage and drive it on the road. Nobody can compel me to do it. But if I have a patent, say for example, on a pharmaceutical product, and I am not utilizing it, there will be a compulsion on me to use my patent. I cannot sit over my patent. So there is a compulsion on use of intellectual form of property when it comes to grant of right, because these are the rights which are granted by state and they are not automatically granted. One has to acquire. There is a one can say there is a process which is prescribed under the law, and only when you follow that and when you become eligible, only then you have those rights. So that is how we look at the intellectual form of property. More to come on the conceptual aspect to it in couple of the slides. Be with me. Intellectual property genesis, if we are assessing, by all means, it's a human intellect and creativity. Now, starting from an alarm clock that noises in the morning to an interesting novel that makes us dream at night. I think these two illustrations have also undergone a change thanks to human creativity and intellect. I don't think we would find alarm clock these days as a routine household product, because our palm size world, that is the phone, is having all these facilities. Hardly few people still read novel because most of the people are on social media and trying to go with their routine stress buster, and that's how they manage themselves. So both these differences that we can look at now are also because of human creativity, human intellect. So all the products that we use, starting from the pharma product to a car, to a phone, to a novel, to a movie that we watch, every such thing is a product of human intellect and creativity, and that is precisely what we're going to talk about. Now, if we keep everything the way in which you can see it on the screen, right, coming out from human brain, it would be very messy. It would go haywire. Hence, and believe me, friends, humans have had this tendency, and they have proved that they always try and come out with a particular system which is very beneficial. So that's what we human have done, and we have come out with a system for protecting this kind of product of human intellect and creativity. And that's how we have intellectual property, that's how we have intellectual property laws, and that's how through those intellectual property laws we acquire intellectual property rights. Now let us look at the, as a teacher, basically I can't help but to define terms. I really need to know what is the definition. But I tell you, friends, in case of law, there are multiple terms which are better understood than defined. Why? Because it is not possible to put it in a watertight compartment or in few lines or few words. So it has to be based on common understanding. So the common understanding that I have been able to derive through my experience in this field tells me that intellectual property is a combination of human intellect, skill, and labor. All three must coexist. Only then the resultant product would be an intellectual property. Like, say, for example, I have a wonderful idea of writing a poetry on a bright sunny morning, but then it's just an idea. I need to have language as skill by my side, and then even with that skill, there are many who don't write. Why? Because they don't want to undertake efforts. So the labor part is also very important, which is in form of efforts. I need to pen down those words in form of poetry so that it becomes a piece which can be copyrighted. In this is something which stands true all throughout types of intellectual property. So this is how one can define intellectual property, which is a combination of human intellect, skill, and labor. It has been said that intellectual property is intangible, but if you just say intellectual property is intangible, I think it's not wrong, but it is incomplete. One has to add having tangible expression. Intellectual property is intangible, which has tangible expression, as I mentioned in the earlier illustration. If we are just having an idea in our mind, which is also given shape through words, but it is not being given a form, which is a tangible expression, it can't reach others. It cannot take a form which becomes protectable under this system of intellectual property. So intellectual property is intangible, having tangible expression. It's also a form of property. However, it's a different form of property, and that is how there are certain limitations. There are limitations like providing for compulsory licensing. As I mentioned, if you have a patent on pharma product, you can't sit on it. You have to use it. If you are not using it, there can be a person, a third party, who can file for a compulsory license. And if the patent holder is unable to provide legitimate reasons for it, then it can be granted under compulsion to that particular person who's demanding it. So in this manner, there are compulsions. What is the reason for these compulsions? That I will tell you when I will take you to the rationale for protection of this form of property. The first block that I have mentioned on my screen is telling us that it's a reward effort and recognize, it is to reward effort and recognize creative contribution. It is a dual system for recognition. An individual's creativity is recognized, and at the same time, people at large are also benefited. I think we have come a long way as far as the technological development is concerned, technological advancement is concerned. So it's a dual mechanism for recognition. It rewards the efforts and it recognizes the creative contribution, which again adds to the intellectual wealth. How does it add to intellectual wealth? It helps to identify, protect, and exploit potentially valuable creative work. And for that, it helps to create a better understanding of various legal rights for protection of creative efforts. So in that manner, the creative effort which are converted into creative work are recognized and are allowed to be titled or entitled as a particular right, and then the potential value can be utilized. So in a way, one can say that the rationale for protection of intellectual property is twofold. Not only to see to it that an individual's creativity is recognized, but also to see to it that people at large are benefited. That's the reason we have provisions for compulsory licensing, because the state, when it is granting these rights, is well aware of the fact that it is not the individual interest for which it is granted. The larger interest stands on a higher pedestal, and that is something which is required to be taken into consideration, hence such provisions. So that is how it is for individual and for people at large both. It also helps us increase the involvement of human resources in research and induce them towards being more and more creative. Imagine, friends, how we have traveled. It help us keep rotating the cycle of innovation. Like, I'm sure Graham Bell, who invented phone, must not have thought that the phone he invented, which was required to be used with both the hands, will reach to a level where there are palm-size sleek instruments which are having the entire world in it. Nobody thought when the phones were invented that phone one day will take this shape and this kind of advanced level of creativity. So this is all because of the system which is there in place to recognize. And friends, it's a human tendency to be recognized. There is an urge that all of us are having to be recognized. We want ourselves to get recognized. So this recognition is not only helping us push ourselves further with creative efforts, but it is also ultimately adding to the intellectual wealth of the country and of course to the economy. So this is what we need to know about the rationale. Now going to the types. Before we go to the types, let me give you that there are these two broad bifurcations, and these bifurcations come from WIPO, that is World Intellectual Property Organization. This particular organization is a global organization that is dealing with each and every aspect of intellectual property, and it is significantly contributing towards maintaining the harmonization of law by way of maintaining the international treaties and conventions. So this particular organization told us that intellectual property be divided into two parts, that is industrial property, which will have patent, trademark, geographical indication, and geographical indications and industrial designs, and of course copyright and related rights, the creative expressions in form of literary, artistic, dramatic work, cinematography will fall in this category. Let me now take you to the forms of IP rights which are recognized in India. So I'm sure, friends, now we are clear as to what is intellectual property. We are clear as to where we can locate intellectual property in the classification, as far as the classification of property is concerned. We are also clear with why the intellectual property is required to be protected. We are clear that it is granted by the state. Now we are looking at the forms. Very briefly, I will take you to each one of these, and then I'll take you to the significance, and then lastly, I'll throw some light on the challenges that this field of law as of now is facing. Trademark, patent, copyright, design, geographical indications, and trade secrets. Let us start, and all of them are, I have also named the acts with the years so that you all can definitely know. Most of them you are finding to be, in the 90s. Why? Because intellectual property regime has got an inevitable international dimension. That also I will tell you when we'll go to that particular part. Let me just brief you on trademark. I think starting from the toothpaste that we use in the morning, which is, say, for example, Colgate, to Facebook and WhatsApp and Amazon, Samsung, MasterCard, Coca-Cola that we drink, Google, without which the life is incomplete as of now, all these will fall in this category. But in order to simplify it for your understanding, the way in which I am recognized as Nidhi, these all products and services are recognized by their individual names. So it's nothing very complicated, but it's a visual form of a word, or it is a device, or it's a label which is applied, which creates a distinct identity for that particular product. We need not read Apple. A half-eaten apple logo is sufficient for us to know that it is Apple, right? Nike, a tick mark is sufficient. So in that manner, that is a product which is recognized, and it must distinguish such goods from goods manufactured by others in trade is the only requirement. Of course, there are technical sides of it, but I'm not going into it. I'm just trying to give you an idea about what is a trademark. So it's an identity of the product, and this identity is created with the distinctiveness that the trademark is, that the mark is having, and it is for both. It is for products and it is also for the services. Now, trademarks are very close to us. Why? Because it tells us what's the origin. So when you take, say, Tableron, without the wrapper also, this particular chocolate will tell you that, okay, this is Tableron. It somehow creates such an impression in the mind of customer that it serves as an unchanged quality, guarantee of an unchanged quality, and it also helps advertise the product. So it helped the trademark proprietor earn goodwill, and that goodwill will help run business and capture market. So it's a very, very important form of intellectual property. Let me now take you to what is a copyright. I'm sure all of you will agree that since last 3 months, the kind of life we are living, and especially the first month, which was very difficult, without having such creative expressions, we would have been very, very depressed, right? Most of us were glued to Netflix and Amazon, and we could pass our time in a way constructively watching certain things, certain series, documentaries, whatever interested us. So in that manner, copyright is something which is very, 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 you can say, an important part of our day-to-day life. We do not recognize, but we share a lot of space of our life in form of literary, dramatic, musical, artistic, intellectual work, right? Now here one has to understand, when copyright is granted, right, it is granted to original work of such kind of expressions, and they are granted only and only to the creative expressions. No idea, fact, system, method, or process or of operation are protected. So if I was talking about the idea of writing a poetry, that particular idea, once penned down, can be utilized by anyone in the world. What is not possible with this particular protection is, you cannot copy it as it is. The reproduction is not permitted. The copying of that work is not permitted. However, the idea, the theme, which is there can be used. And I think all of us can very well see that if that would not have been there, most of our dramas, movies, series, web series would have been useless, right? Because most of them are on the same theme, on the common idea, and we thoroughly enjoy it. So the life of copyright is in the creative expression and not in the idea. That is something which is important. Copyright is reasonably protected for a longer duration compared to others. I'll take you to the terms also so that you know as to how these rights are protected. So copyright is something which is protected as and when it is created. You can see on my slide, C in circle, which is a copyright symbol with my name and the year. I think this is sufficient under Berne Convention to convey that I have secured statutory protection. It's always good to go ahead with the registration because it will help you fight legal battle in future if you so have to. Otherwise, there are no further formalities as far as copyrights are concerned, which is a very unique part of copyright rights which are granted under copyright. So, trademark, a distinctive term can be added to it. To understand copyright, the original creative expressions would form part of copyright. And now I'll take you to patent. Patent is something which is one of the most important part of intellectual property. It is an exclusive right which is granted for an invention. And what kind of an invention we are talking about? It is granted to a person who has invented a new and useful article, or an improvement of an existing article, or a new process of making an article for a limited period of time. Our life is much smoother because of every day being every day because of the pharmaceutical products and the advancements, medical advancements which are being added to it on regular basis, right? This small illustration can help us understand what is the significance of patent. Beyond this, although starting from a hinge in your drawer to the mechanisms that we use in our computer, in our refrigerator, in our car, whatnot. They are all part and parcel of patent. And product as well as process, both are protected under patent. It is an exclusive monopolistic right granted for 20 years. And it is something which is known as functional solution to existing problems. Microphone, how microphone must have been created? I think that's the requirement, making yourself audible to more than 50 people in the same, speaking at the same decimal. How is it possible? Innovation, microphone. So we got it. And the rights are granted. Of course, it's not that easy. There are essential requirements. All inventions are not patentable. Only those inventions that can satisfy these requirements are patentable, are patented rather. That is novelty. The patentable invention has to be new. And friends, the requirement is the novelty will be judged globally for granting rights nationally. So, new throughout the world. It has to have inventiveness or inventive step as we know it under Indian law, meaning thereby the invention which you are claiming to be patentable should not be obvious to those who are skilled in that particular field of study. And of course, it has to be useful. Do not forget the second objective as part of rationale that we discussed, which is to grant right not only to recognize an individual's creativity, but to see to it that people at large are also benefited. So for that, usefulness, utility through industrial application is the key. And if you can see on the slide, there is a shoe picture. This particular shoe is a patented device which was added to the heel part, and this was known as Michael Jackson shoe. He used to wear this so that when he's leaning beyond the level of gravity, he would not fall down, and it would create an impact of him being able to dance in the air. Doesn't mean that I'm not at all undermining his ability as an excellent dancer, as an excellent artist, but this is what he used to wear and he used to take help of. Those who are interested can just search this in Google and would come to know how interesting role is being played by patent for such things. From patent to geographical indication, these are two distinct poles. In case of geographical indication, we are talking about the products that you can see on the screen. They are like Darjeeling tea, basmati rice, champagne, Kolhapuri chappal, Kanjipuram silk. What does it tell us? What is common in all these? One thing which is common in all these products is the unique characteristic which are having direct attachment with the geographical area from which it originates. The unique characteristic which becomes an identity of these products are attributable to its geographical origin in place. Number one, it is attributable to the to the typical climatic condition of that geographical area, like basmati rice or Darjeeling tea. If I buy 15-acre land in Ahmedabad and start growing tea plants, will I ever get the aroma that I want in my tea, which is somewhere even near to Darjeeling tea? No. Why? Because it's not the defect in my agriculture, in the methods that I employ for that. It is something which is the climatic condition which is giving that aroma to basmati rice or the length of the grain, right? And it is not so it is not something else. So that is how, in this way, the uniqueness, the unique characteristics are added and attached to a product because of the climatic condition. The second way in which such uniqueness is attached to the product, thanks to the skills of the people who belong to that particular geographical area, like Kanjivaram silk, like Patanna Patola from Gujarat, Kolhapuri chappal from Maharashtra. Then one can take illustration of Pochampalli Ikkat also, right? All these are such kind of products which are created thanks to the age old skill, which is a form of traditional knowledge which has transferred from generation to generation. And that is how these unique products are given to us. And it is very important to recognize such products, which can be agricultural, which can be natural, which can be manufactured, or which can be a product of handicraft. And their recognition comes under geographical indication. And the most important part of this particular type of IPs, the rest are individual form of right. This is a collective right, and rightly so. If it is about recognizing the geographical region or the uniqueness of the products thanks to the geographical region, as I just mentioned, then by all means it has to be a community right. If it is individual right, it would be unfair. These are the illustrations further that you can see: basmati rice, Darjeeling tea, Kanjivaram silk, Alfonso mango, Nagpuri orange, Kolhapuri chappal, Bikaneri bhujia, Agra petha. More than 350 products till date have been granted geographical indication tag, which one can see when you go to the IP Office of India website. That's the list is available. And interestingly, many products from handicrafts and agriculture are getting recognition under the GI tag. Let me now take you to industrial designs. The industrial designs is something which is also forming a very important part of our life. The life is very interesting because of such kind of products which are being bought solely for its appearance, something which appeals to eyes solely, right? People are ready to forego technical advancement when it comes to appearance. If I have to buy a refrigerator, I should definitely be looking more and paying more attention to the technology. But it's possible that I may reject that technology. Why? Because the color that I wanted, which would go with the attire of my kitchen, is not available as far as that kind of company of refrigerator is concerned. So I would compromise with it because I'm more concerned with the non-functional appearance of the product, which appeals solely to my eyes. So we are talking about the features of shape, configuration, pattern, ornament, which is applied to an article. And this kind of designs are very important, starting from the watch that we wristwatch that we wear, to the car we drive, to the laptop we use, to the chair we sit on, everything will fall under this category of intellectual property, and they all are protected and granted only when you have registration. You need to have a design which is new and original. You need to have a design which is non-functional. The functionality is just not to be taken into consideration. And then when it is meeting with all those requirements as prescribed under the law, it can be granted with the rights which will last for 10 years and can further be renewed for 5 years. Let me now take you to trade secret, right? There's nothing which requires, in a way to define this particular part. I think all of us have tasted major, I think, brands of colas that are available in our country, like say Pepsi Cola or Thumbs Up or Coca-Cola, right? And when all three of them are being served to us in a transparent glass, we can definitely recognize which one is Pepsi, which one is Coke, and which one is Thumbs Up. Right? Why? Because they all have different and distinct formula. This is one of the most famous illustration of a trade secret. But trade secret is something which can cover anything and everything. Whatever you want to keep secret, whatever is giving you commercial advantage, whatever is something which you are required to protect, and you are required to protect the through protecting the confidentiality of it, would fall under this confidential information or trade secret, right? As I mentioned, trade secrets are confidential information that has commercial value by virtue of being kept secret, and reasonable steps have been taken to keep it a secret. It can be a formula, pattern, physical device, idea, process, compilation of information which is not generally known or reasonably ascertainable. All these things would fall in the category of trade secret. Let me now take you to the term of protection along with the registration requirement. Friends, in the beginning of the presentation, I made it very clear that these rights, because if I talk about the jurisprudential concept of right, there are three categories of rights. The first category of rights are those which are available to us, for which we do not have to do anything, and no requirement of meeting with any condition is laid down, like human rights. You just born as human rights and you get those human rights. The second category are constitutional rights. Being citizen of a particular country, you will be granted and you will be protected accordingly. And the third category of rights are statutory rights. Intellectual property rights fall in this particular category, and hence there are formalities which are required to be fulfilled. They are not available as a matter of course. So what are those formalities? The registration requirement, the essential for being eligible to claim that protection. Then again, there are two ways in which your protection is approved: on a registration or without a registration. In some cases, it is only on registration. In some cases, the registration is not compulsory. However, it is wise and is highly recommended to get registration. Patent and industrial designs are such which are available only on registration. If you do not have registration, you certainly have no rights. If somebody else goes before you and get that particular right, even if you were the one who invented it, you will not be able to have any sort of legal mechanism by which you will be able to secure or re-secure your rights. In case of copyright, trademark, and GI, it's not compulsory but highly recommended. In case of trade secrets, of course, no registration, because you have to keep it secret. And how long is it protected? Till you keep it secret. Patent is a non-renewable, monopolistic, exclusive right granted for 20 years. Copyright, in case of literary work, lifetime of author plus 60 years. However, different type of work has different duration, like musical work, dramatic work, photograph, cinematograph, film, so on and so forth. Trademarks, initially in the first instance protected for 10 years and then can be protected in perpetuity. Why so? Because trademark is related with goodwill which is established in the market, and that is how, even if it is even when it is not protected, it is not registered, it is protected, and when it is registered, 10 years and can be in perpetuity. Same goes with GI and industrial designs, I have already mention. Let me now take you to the significance part of it. Now, what is the emerging? Why are we talking about this? Why people are saying that it's a new world, it's a new emerging field? Why people say that it's a buzzword as of now? I don't think it is something which is a new or um, a novel field which has suddenly come to us. If we talk about the Indian patent regime only, forget the global patent regime. The first formal legislation that was there for granting and recognizing patent in India when we were ruled by Britishers was way back in 1856. We are in 2020, right? So it's not something which is new. Yes, I agree that the recognition is now given, and that is how it is due to the emerging importance. Now, what are the reasons? There is a growing awareness for potential that intellectual property has for economic gain. I think the world has realized that gone are the days when the when the economy used to be standing on two pillars of capital and labor. A third and very important pillar of knowledge is added, and this particular pillar has transformed the status of has converted the status of the economy, has transformed the economy from a single economy to an economy of ideas or knowledge driven economy, due to which the world has started thinking very seriously about it, and there have been multiple negotiations being undertaken on regular basis so that there is harmonization of laws. Again, by harmonization, which is harmonization means minimum standards of protection required to be set so that it does not keep changing with the change in the border of the state. So in India X and in US Y, that should not be there, because as far as human creativity is concerned, it should be made available to maximum number of people for taking benefit or advantage out of it. But without a layer and an umbrella of protection, it would not be possible. It would just get stolen away. In the due to the advancement of technology, one can see a very sharp eclipse of national boundaries, due to which harmonization of laws is a requirement. So in that manner, I think all these are sufficient to convey that we are now in an era which is an era of knowledge driven economy, and hence one cannot afford to undermine the significance and importance of IP. For a country like this was from the global point of view, for a country like India, which is very rich in genetic resources and traditional knowledge, intellectual property protection is very, very significant, very, very important. The management of IP has great significance, and that's how we need to address this at all level, national and international legal framework and policy framework, both simultaneously. That, of course, through challenges we will try and look at. When talking about intellectual property, it would be incomplete. My presentation would be incomplete if I do not touch upon the international dimension of the IP system that we have in India. The international dimension, which is inevitably added to our country's IP system, is thanks to more than 25 international treaties and conventions. They all are outcome of negotiations among multiple countries, and they are in form of common understanding that have been articulated in form of provisions of these international conventions and treaties. They are divided into three parts: IP protection. It has all these different types of international conventions. It has another category, which is global protection, and then on classification. These are little technical things. I'm not touching upon it. But I just would like to draw your attention to one thing, that thanks to these kind of international treaties, we have a completely different system of IP now in place. One of them that I need to bring to your, a few of them that I need to bring to your attention is Paris Convention, which you can see on the slide. You can see the you can see the Berne Convention, and the most important thing is the trade related aspects of intellectual property rights, and these kind of conventions have added a lot to our existing IP system, because being signatory to them, it is an obligation on us as a state to meet with the requirement which has been laid down, and we need to reflect them in the legislative framework of our country. So it has changed accordingly. Let me now take you to the next aspect and the final aspect of our discussion, and that is the challenges. I'm sure I have tried my best to convey the concept of intellectual property, the types, the rationale, and the significance, and also the inevitable international aspect. So, if India is having certain ways in which we are handling our copyright or trademark or patent, they all are influenced by the global standards now. It's not just individual countries take on it. It is global understanding, and with harmonization of law, it will be reflected in the country's legislative framework, which is so in our case as well. When we are talking about challenges, what I have in front of you, if you have counted the blocks, they are just 9, right? The list is not exhaustive, and we don't have time to deal with everything. Whatever is something which is which forms part of our day to day life, I have brought it. There are a number of legal technical aspects which are also subject matter of challenge, but I have not brought it to my presentation and made it part of my presentation. We will be discussing only those things with which we are connected, and they are very much part of our day to day life. Let us start with the very first challenge, which is patent and right to health and access to medicine. I think, as we know, right to health is a fundamental right, right? And as far as this fundamental right is concerned, the fundamental right cannot be enjoyed or exploited to its fullest unless we have a right to access, or we have access to medicine. And why are we talking about when we are talking about patent? The world's patent in form of process and product is granted by all countries. Pharmaceutical products would form almost half of it. Most number of pharmaceutical products these days are being patented. So why and how right to health and access to medicine will come in here or come in picture? Whenever there are rights which are granted in form of patent, product or process, that will then be put in a particular locker for 20 years. Unless and until there is a permission which has been granted by the patent holder, the use of the same is not possible. So that is how generic medicines, right? Generic medicines are created only after the term is over, or with the voluntary or compulsory license. Otherwise it is not possible, and that is how it may create certain issues. This is an issue not only India is facing, but the world is also facing, and in this age of pandemic, this issue definitely may create certain problems in future. I do not know, because we have yet not been able to come out with the vaccine. Once we have that, then rights on it, then manufacturing of the same, then selling of the same, so on and so forth. There's also another part which I would like to highlight, which is a very important provision, couple of provisions which we have, where we are trying to strike balance as far as the right to health and access to medicine are concerned. That provision is, one is in form of compulsory licensing. If there is somebody who is giving out license at a very high price, then there can be an application which can be filed, and then on a particular product which is part of day-to-day life, or which is part of right to health, then it can be allowed by the Controller General to be on the made available on the compulsory licensing. So that is something which is there. And section 3D, I'm sure few of those who are participants today must have heard about the famous Novartis case, where the Indian legislation through judicial intervention is trying to check on evergreening of patent, so that one patent is not presented in a different form, and then again for 20 years it is put in a locker. right? It should come back to public domain. That's a requirement. That's a philosophical aspect as far as the objective of grant of patent and the rights on it are concerned, because it should be protected for some period of time and then it must come back to public domain, so it is available to people at large. These are few important things which are in form of challenges as far as patent is concerned. Another thing is software patents. I think we have recognized this particular, the importance of software patents much more in last 4 months, right? The world is now running virtually, the physical world, and like I am able to reach out to all of you. So in that manner, the importance of software patents is huge. But we have protection only and only in form of copyright. We do not have patent protection. Of course, there are philosophical framework. There is a philosophical framework with which it can be answered that the software patents are not protected because they are abstract ideas. They do not satisfy the requirement of patent, which are there as we saw under novelty and inventive step, right? So they are abstract ideas, they are algorithms. So under section 3K of Indian Patent Act, software's algorithms per se, computer programs are not patented. That is a particular challenge that we are facing as of now. US, of course, protects software and grant them patent. However, we don't. Another important thing which is also very much part of our life is standard essential patents. Whenever we buy a particular phone, right, these days that requirement is something which is one of the most essential requirement. We really want it to be compatible to all important things like Bluetooth connectivity, internet connectivity, USB connectivity, so on and so forth. Now, how do we get this and how does it function? There are certain standards with which it must comply with. And in order to comply with those standards, there are certain inventions on which patent is granted are required to be used. Now, it is a moral duty of those who have already acquired patent to grant license on a reasonable term, which are fair, reasonable, non-discriminatory, so that it is used further. But it is not happening. There is no reference under Indian Patent Act as far as standard essential patents are concerned. Of course, we have entered this era. There are judicial interventions. There are certain policy in form of guidelines which are made available, and accordingly it is being followed, but as of now it is not at all there. And this is made part of the national IP policy of India also, that we need to come out with the concrete legal or statutory framework for addressing the issue of standard essential patents. Coming to trademark, trademark is being used more in virtual world these days than in physical world, right? Especially in this time, since last 4 months, most of us are looking at things and purchasing them online, so they are being used online. So they can be used as domain name, they can be used on a website, they can be used as a meta tag, or it can be a sale of the trademark as keyword, so on and so forth. There, how to actually help those who are facing violation, those who are facing infringement, because we do not have separate set of legislation that can help us address this. It's a time when we need to have at least make certain changes in our trademark law, so that every time the answer is not required to be sought from the judiciary, and the statutory framework can help us protect our trademark in the virtual world also. Otherwise, the judiciary through cases, through precedent, has to say that it is something which is at par with trademark in physical world, hence be protected virtually also in the same manner. So that is little time consuming, and that is little, you can say, complicated also at times. Let us now look at this counterfeiting, right? You can see all these products, friends: Colgate, Coca-Cola, Kit Kat. Multiple counterfeit products are available for all popular. They definitely infringe the trademark, right, of products. But the thing is that more the worrisome part is, rather than the legal rights directly being attacked, the more difficult part to be handled and addressed is how they are capturing the business share. So if you purchase a counterfeit thinking that it is the original one and it does not meet with the standards of the quality, you will definitely not go back to that product. The market of the original product is reducing. The commercial reputation is being lost. The goodwill which is being established over a period of time is also being lost. Now this is something which is a very clear case of infringement if or passing off in case of registered as well as non-registered mark. But in case of the way in which the rampant speed with which it is happening and the different forms in which it is happening, it is a challenge. And Trademark Act alone somehow, or Designs Act alone, the pirated version, is not sufficient to address this, to handle this. This is not just India's problem, it is globally a problem which is required to be addressed. There are particular remedies which have been added taking this into consideration, but it is not helping to a great extent, because in India there are multiple other crimes which are required to be addressed rather than such kind of crimes for which concurrent or parallel civil remedies are also available. Let's now look at piracy. Piracy is nothing but copying, stealing, reproducing, transmitting, or selling of the intellectual property, right? Mostly copyright, or maybe industrial design also. Because as far as copyright is concerned, the first and the most important right which is available is right to reproduce. Right? Say, for example, when I have written a book and you have purchased the book, I have intellectual property right in it, but you have physical form of right in it. So if you read my book, you do not write like my book, and you tear it apart and throw it in the dustbin, can I sue you? No, I cannot, because you were free to do whatever you want to do with the physical form of it, but you have taken 10 photocopy of it and you are circulating it, right? That is something which is reproduction. That is my right. You capturing my market, you are affecting the marketability of my copyrighted version. So that way we need to address this, but I'm sure it's very very difficult to address this, because pirated softwares, pirated versions of music, pirated movies, everything is so rampant. And that's how we get to see Shah Rukh Khan or maybe any other celebrity with folded hands requesting us stop piracy, because that is something which is really hampering their economic interest as well. So that way piracy is something which is required to be addressed still in a better manner, and that is something which has been highlighted under the national IP policy objective 3 as well. Artificial intelligence and intellectual property. Now, in case of artificial intelligence, it's everything which is done by a machine. So where is human intervention? And without human intervention, where is that human touch? So how to identify an author or a creator? Because across the globe, whenever we are granting rights, the author has to be a human. Owner may be an organization, company, anyone, but the author has to be human. Now here, that particular part is missing. So what is the best regime for protection? Should we recognize a non-human copyright or patent, or perhaps a new neighboring right for producers? Where is the author's own intellectual creation in works produced by computers or robots? These are unanswered questions, and the world is looking for answer. So I'm nobody to answer this. I'm just trying to throw these things to your mind so you can think about it. Another important thing which is for us is protecting traditional knowledge. India is a country which has got huge traditional knowledge, which is in form of knowledge or know-how, skills and practices that are developed, sustained and passed on from generation to generation within a community, and often it forms part of the cultural and spiritual identity of it. We do not have any separate legislative framework for it. In fact, WIPO, as I mentioned, World Intellectual Property Organization, is extensively working on coming out with an international instrument for protection of traditional knowledge, because number of countries are having huge traditional knowledge related products and things which can be protected. So that is something which we are looking at, and India is also trying to protect. Of course, there are policy mechanisms, there are non-legislative instruments, there are private order regime which is addressing it, but nothing can actually be compared to having a law or an international instrument for the better protection of it. Again, geographical indication, we have an act. All states as of now, including Tirupati Laddu and the Rasgulla of Odisha and West Bengal, we have heard these stories, are running a race of getting a GI tag to as many products as possible. It's good. But then what happens next? GI is a legal vehicle for socio-economic development of India, but it would not become, it would certainly not, will not be able to utilize it unless and until we come out with an all-inclusive approach for the brand promotion of GI. Our local products can capture global markets, but for that we need to come out with a mechanism. There has to be a profit sharing mechanism at all level. All stakeholders should be involved. There is a need to address lack of awareness and unidentified potential GIs as well. I myself have conducted an empirical research on it and have found that those who were granted the tag were also not aware that they already have this right. This is the state of affair, factually speaking, as of now in India, in most of the states. That is a challenge for us, how to address, how to meet with these requirements. We do not have a law. In 2008, we made an attempt to come out with a law for protection of trade secret, which was titled Innovation Bill, but it died its untimely death, and since then we do not have. Does it mean that we just do not extend any protection to trade secret? We do, but that is in form of contractual breach of contractual obligation, and a civil remedy is available there. Generally, if you are talking about the trade secret as confidential information. Criminal remedies, I'm not touching upon it because I'm looking at trade secret as of now only as a form of intellectual property. So this is something which is another kind of challenge. After talking about all these different challenges, what is the way forward? There are multiple things which can be done, but two things are most important, and that is, one has to be very, very particular throughout the cycle from concept to commercialization, any form of IP. Awareness and enforcement, both these aspects are required to be addressed. And why we are facing these challenges and what are the problems? Number one, by now we know that management of IP and IPR is a multi-dimensional task. National, international, both are there. We need to look at the actions and strategies which are aligned with national laws and international treaties and practices. We also know that it is something which is not just a legal field, but it has science, engineering, medicine, finance, marketing, economics, everything is involved in it. So it requires a very distinct approach. Again, different form of IP requires demand different treatment, handling, planning strategies. So one size fits all approach is not something which is possible here, or which will help us sort out all these problems, or which will help us meet with these challenges. We really need to keep growing. We really need to evolve with the international practices, and then as and when we have to change, we must change our IP policies, the management style, the strategies, depending on the area of specialty. I'm extremely thankful to the organizers for giving me this opportunity for sharing my thoughts on the subject, which is very close to my heart. Thank you very much for this opportunity. Over to you, ma'am. Sunita, ma'am.
Over to Indira, ma'am.
Ma'am, there is one question which is asked by Mr. Swarup Tamineni. His question is, kindly elaborate on 9N IP relating to the music industry where the lyric writer is also demanding for the IP. So he wants elaboration on that, ma'am.
Okay, now as far as the music industry is concerned, there are two categories of rights. The lyricist would not get direct rights because, in fact, the one who writes for it will be in the category of work for hire, and it would be, paid to. He will be working for somebody. So there are no direct copyrights. There are only moral rights, no economic rights, as far as the lyricist is concerned. The second important thing is that as far as music industry is concerned, there is a concept of neighboring rights. So the broadcasting rights and the rights which are granted to producers of phonograms, they have right for dissemination of this music. So they will have those rights. Lyricist will have right in form of moral right and can only claim that this is my creation. Beyond that, there is nothing that the lyricist would generally have.
Thank you, ma'am. Thank you for enlightening on us on the different issues in IP, intellectual property. Uh, Now I request Sunita ma'am to propose vote of thanks. And in person, I thank Nidhi ma'am for sharing such a informative session, ma'am. And not only that, I also thank our head of department and the convener of the webinar, Sunita ma'am, for giving me this opportunity. Over to you, ma'am.
Thank you, Indira. At the outset, I thank Nidhi Madam for giving me the opportunity to make an arrangement for the webinar. Ma'am, as a technical person and academia, you have put all the relevant things into perspective for us. Your presentation has enlightened us with various diverse and technical terms of IPR, such as patents, trademarks, industrial designs, copyrights, trade secrets, and GIs. Your examples have enabled us to understand them with ease. Your commitment has enabled us to meet the goal of this webinar, that is, to provide our audience the useful insights into the field of IPR. Thank you, ma'am, for your support and contribution, not only for the webinar, but also to the field of intellectual property rights. IPR will continue to impact on our lives till the day humans stop getting creative. Thank you very much, ma'am. I thank our DG sir for his permission. I thank our DG sir, Sri Abhirama Krishna sir, for his support and permitting us and taking part in this webinar. I extend my sincere thanks to Dr. M. Srinivas sir for his constant support and guidance in conducting the webinar. I extend my thanks to Ms. Indira Madam for being the coordinator. My sincere thanks to Mr. Naveen for extending his help in making the necessary technical arrangements for the webinar. My thanks goes to all the participants who have participated. Without your participation, this webinar would not have been successful. My special thanks to HAYATH BASHA, technical person who has helped us in conducting this webinar. Our special thanks to all the international participants from Saudi Arabia, Yemen, and UK. I thank each and everyone for making this webinar a success. Thank you. Thank you.
Thank you and congratulations. Madam Nidhi Madam, thank you very much, Madam. There was a question from our Director General, sir.
Yes, I can read this. Right.
Yeah,
I think, sir, thank you very much for appreciating my presentation, sir. And the question that has been put by sir is what is the requirement of taking permission when in the PowerPoint presentation when the teacher
yeah,
is borrowing model from somebody else. Sir,
yeah.
there is an exemption as far as the PowerPoint presentation which is being made by teacher is concerned, because it is considered to be part of the instructions which is given to the student, and there
Okay,
the fair use concept will work, and that is how no such permission for educational purpose is required here. The student,
okay.
and
Thank you
there
very
the
much,
fair
Madam.
use concept
Thank
will
you.
work, and that is
Okay, thank you very much, Madam. Once again, thank you
thank you,
all and
thank you,
congratulations.
thank you,
Thank you, Madam.
thank you,
Once
Thank you,
again,
ma'am.
thank you,
thank you all and
thank you,
congratulations.
Thank you, ma'am.
thank you.